mentioned, my lord directed me to inform the other side and come back at 2, my lord.
What is the urgency?
My lord, interim order is expiring tomorrow, my lord.
Are you aware about the interim order?
My lord, your lordship asked me to file a report, not a report, but an affidavit which has been filed before the
Let me see.
district magistrate, my lord.
This is the last page is the operative portion, my lord, long last.
It was never mentioned that there was a tenant in the premises. A report to the
I am for the respondent bank.
Bank, while submitting the application, my lord, it was never stated that there was a tenant in the
It is
premises.
not mentioned.
The affidavit are annexed.
Because since the initial, my lord, my submission before your lordship that regarding the maintainability of the writ application, but I am objecting
Which bank?
Union Bank of
Union Bank of India. It's not a nationalized bank.
Nationalist Bank.
It is a nationalized bank.
My lord.
Then why will the writ petition not be maintainable?
My lord, that is the in view of
Alternative remedy.
yes,
Alternative remedy.
Yes, my lord, that judgment also referred in your lordship's order, my lord. I have
My lord,
submitted
on the
subsequent judgment also I have, my lord. That is also same that the my lord, if I may hand over, my lord, your lordship kindly see the
my lord, on the last occasion, my lord, I referred a judgment, Walful, my lord.
1 minute.
ওয়ালফুলেতে করতে পারবে বলেছে।
my lord, if your lordship kindly turns to paragraph my lord 41 onwards, my lord. May I read it, my lord? If your lordship allow me to read, my lord. It is a matter of serious.
1 minute. 1 minute. এই জাজমেন্টটা দিয়ে এটা অর্ডারটা কি কিন্তু
NAY.
This is also dealt with the my lord, the Bafna judgment which I have referred, my lord, on the first of this.
PHR invent, who relies upon this? You. PHR invent.
Yes. Yes, my lord.
2024-6 SCC.
Yes.
You are relying upon this.
Yes, my lord. That is, my lord, subsequent to the Bafna judgment.
What is this solve?
Well, this is the affidavit, my lord, which was submitted before the district magistrate
By you.
by the bank.
Now in the affidavit, you are required to disclose all details.
Your lordship is absolutely correct. On that day, my lord, the first occasion, I have also submitted that bank was not aware that there was a debt.
Bank was not aware.
My lord, that is the reason for which otherwise, my lord,
Borrower,
yes.
did the borrower intimate the same to you?
No, my lord, they have submitted an affidavit disclosing therewith that free from all encumbrances.
And you will not go and verify? You are required to verify.
But kindly see, my lord, the bank's officers, my lord, verified this area, my lord. They could not found, and there was no intimation because prior to that, cell notice was published. Prior to that, my lord, section 13(2) notice was pasted. Possession notice was pasted on the, my lord, yes, on the place of the.
All right. Now, since when are you in possession?
My lord, I am in possession since 62. I have a civil court declaration that I am a tenant. There was a issue arose between the landlord and the tenant, my lord. Civil court.
Is your landlord the borrower? Is your landlord the borrower?
The landlord and the seller, his seller, his vendor.
My lord,
this vendor is also the party to the civil proceedings. My lord, I have annexed the decree with my writ petition, my lord.
Please show.
Plaint is that my lord, page 271. Kindly see the dependent number 2. Guru Saran Singh.
Page
271.
271.
Next are P6. Isha Bhattacharya is the legal heir of my landlord, erstwhile landlord. Thereafter, they sold the property to these people's Singh family. My lord, Guru Saran Singh. He is one of the person named in the notice as well, which was affixed in my shop.
All right. Is he the borrower? Gusharan Singh?
I am not aware.
You are not aware.
The borrower is not aware. This is the civil court plaint. Subsequently, there is a decree or judgment.
This is a civil suit, the decree. What is the prayer in your suit?
Yes. My lord, prayer, copy of declaration that plaintiff is a monthly tenant in respect of one of the room with asbestos shed on the ground floor situated and lying at premises number 164A. Since my cause of action arose in premises number 164A, I filed the suit with respect to that suit. I'm one of the tenant with respect to 164B as well. There is my workshop and one is my shop room. My lord, I'm reading the prayer, my lord. Entitled to use the
Yes, next, where is the decree?
my lord, decree is at page commencing from 282. My lord, the operative portion, my lord, is at 285. My lord, hen ordered that the suit be and the same is decreed ex parte, but in part the plaintiff does get a degree of declaration that he is the monthly tenant in respect of the suit property and that he may not be evicted from the suit property without following due process of law. My lord, I am led by Mr.
Yes, yes.
My lord, I'm a tenant from 1967. So
Yes.
when the bank has taken the property on mortgage, bank might have done the due diligence and they ought to have known that there is a tenant. Lordship kindly sees the bank's declaration, the copy of which today I'm getting. It clearly says that there is no tenant. At the bottom, the secured asset
Last but one paragraph, my lord.
secured asset is not in possession of any lessee, sublessee, tenant under the valid lease made prior to creation of the mortgage of the borrower.
Which portion are you reading?
Lordship, the last page,
Last portion of the affidavit, my lord, which I have submitted, my lord.
Last portion of the affidavit that you
Last
have.
but one paragraph. The last page.
below point 9.
1 minute.
Last
This
page,
is
my-
the officer in charge Starfacy section.
Yes, my lord. That
Is there
that
statement
document.
of
Last,
yes,
last page.
last page. Yes,
Kindly see.
not in possession of any
Not in
yes.
possession of any.
Yes.
Hmm.
So, and Lordship, I have shown Lordship that I was in possession till from 1967, my tenancy. So there,
When
and
was this loan taken?
this loan, according to this report, is taken on that I do not know, my lord.
NPA declared in 2017. So you are there prior there too.
Obviously has to be prior thereto.
Yes.
And 2016, Lordship kindly sees the learned trial court's adjudication in my favor.
Yes, I've seen. Now the bank.
The bank
What is the
was not-
judgment that you are relied? Bank was not aware.
Bank was not aware and bank was also not a party to that suit.
Cannot.
The suit was passed.
This was between the landlord and the tenant.
Yes.
Why will the bank be there?
Yes, my lord. So, my lord, the bank was not at all aware. And, my lord, the section 13.2 notice was there. Section 13.4 notice and
He
possession.
is no way connected either with 13 to 13.4.
Possession notice was published. It was pasted on the, my lord, conspicuous place of the property. And, my lord, it was a NPS 2017.
Yes.
Till 2017 to 2024. My lord, it is not believable that a tenant who is not aware that the property is going to be sold, bank notice was pasted there in publications were made. So it was, my lord, the notice was published in general so that public can concern with regard to that. But he did not do so anything. Only on the date when the date was fixed for taking physical possession, on that day, possibly he came to learn from any source and he filed this, my lord, the writ application before this court. My lord, if I aware with regard to the tenancy, then definitely, my lord, it was the case of the bank. Bank should have disclosed therein that there is a tenant. Now that is, my lord, on respect of the one thing and another thing, my lord. As per the Supreme Court, several judgments, my lord, a tenant, if it is more than 1 year, then the documents must be registered under section 107 of the Transfer of Property Act.
What about the decree that has been passed by the civil court?
I'm not aware. I'm not bound by the.
Now you are aware?
No, my lord, because it was
Please
not
come.
upon the.
And what were you relying? Which paragraph were you relying
Yes,
from
my lord,
this?
kindly see the judgment, my lord. Yes, paragraph 41, 42. And 38, sorry, my lord, I'm extremely sorry, from 36, 37 onwards. 38 mainly, my lord, it has however been clarified that the High Court will not entertain a petition under Article 226 of the Constitution if an efficacious alternative remedy is available to the aggrieved person or the statute under the action of the complaint has been taken itself contains a mechanism for redressal grievance. Undisputedly, the present case would not come under any of the explanation. We are therefore of the considered view that the High Court has grossly erred in entertaining the allowing the petition under Article 226 of the Constitution. While dismissing the writ petition, we will have to remind the High Courts of the following words of this court. In Satyavati Tandon, since we have come across various matters wherein the High Courts have been entertaining petition arising out of the DRT Act and the SURFACE Act in spite of availability of the effective alternative remedy, it is a matter of serious concern that despite repeated pronouncement of this court, the High Courts continue to ignore the availability of the statutory remedies under the DRT Act and the SURFACE Act and exercise jurisdiction under Article 226 for passing orders which have serious adverse impact on the right of the banks and the other financial institutions to recover their dues. We hope and trust that in future the High Courts will exercise their discretion in such matters with greater caution, care and the circumstances. But this judgment also refer the judgment of the Bapna judgment. And the 17.4 of the SURFACE Act clearly states that every tenant has got right to move the debts recovery tribunal if he agree with thereby any action of the bank.
Please come.
Lordship, may kindly see the judgment which I produced,
You are also producing judgment.
which may be of some
All right, what is it?
Lordship may see the paragraph 22, 2019 9 SCC 94. Paragraph 22. After considering the Supreme Court's judgments in Harshad Govardhan and Vishal Kalsaria, this judgment summarizes the position. After examining the legal and constitutional position, the court held that while the SURFACE Act has a laudable objective providing the smooth and efficient recovery procedure, it cannot override the objective of the Rent Acts to control the rate of rent and provide protection to tenants against arbitrary and unreasonable eviction. To resolve this conflict, this court held that, number one, the provisions of SURFACE Act cannot be used to override the provisions of Rent Act. The landlord cannot be permitted to do indirectly what he has been barred from doing under the Rent Act. Number two, while a yearly tenancy requires to be registered, this is what my learned friend is saying, oral tenancy can still be proved by showing that the tenant has been in occupation of the premises before the magistrate under section 14 of the SURFACE Act. Number three, the non-registration of the tenancy deed cannot be used against the tenant. For leasehold rights being created after the property has been mortgaged to the bank, the consent of the creditor needs to be taken. Here, my tenancy is prior to mortgage. Number four, even though section 35 of the SURFACE Act has a non-obstant clause, it will not override the statutory rights of the tenants under the Rent Control Act. The non-obstant clause under the section 35 of the SURFACE Act only applies to laws operating on the same field. Therefore, my lord, my protection is there. Only thing, the notice has to come in my name. Then only 17(4)(a) I can go before the learned tribunal.
Dear Lordships, kindly give me a day's time. Tomorrow, my lord, I shall bring the subsequent judgment of the Supreme Court.
Regarding what?
Says that if a tenant is more than 1 year, he has to give a registered deed.
My lord, I am under Bengal
That is
Tenancy
a-
Act.
Listen,
State Act.
where there is a dispute with regard to tenancy, then your judgment will be all right.
No, my lord, kindly give me 1 day time, my lord, because I have to see that.
Here his right has been crystallized by the order passed by the civil court.
But no, that is absolutely. I am not on that. I am saying that subsequent to this judgment, the judgment which referred, my lord, by learned friend, subsequent to that, 2022, 2023, there are several judgments of the Supreme Court by which it has been stated a tenant who is more than 1 year, he has to produce the registered agreement for sale.
For what purpose?
Not in West Bengal.
What
madam.
For what purpose? What is the purpose?
To show his bona fide.
Right, his bona fide is crystallized. Had the civil court's order not been there, you could have raised an issue that he is not a tenant. He has come in after the mortgage was taken.
I was not a party to that process.
You are not required to be a party.
They did not choose to intimate to the bank in spite of the all publications, everything
Bank
was
has to
done.
do the due diligence.
What steps are you taking against the borrower who took loan from you by suppressing material facts?
The Lordship's order, my lord, his property has been sold. We have handed over the property to the purchaser, new
Yes, then
purchaser.
purchaser steps in.
Realized.
Then purchaser steps in.
Your Lordship was pleased to grant.
As is where is basis.
Yes.
Petitioner will remain. Let you purchase. The purchaser will take possession with the tenant. It's not that you evict him and then you give possession.
Purchaser
I have
steps
to
in
hand
into the
over
place of my landlord.
entire property because condition of the sale was that I should hand over the entire property because he has paid the
Entire
money for the entire
property includes the tenant.
My lord, that
How
is-
can you evict him?
My lord, subject to my lord, I am extremely sorry. Kindly give me a day's time, my lord. I shall produce the judgments, my lord. Required judgments, my lord, tomorrow. Kindly keep this matter, kindly. At least for my lordship's satisfaction, my lord, I shall submit this judgment.
It is not for satisfaction of anybody. It is for ends of justice. If you want those judgments to be brought in, it can be brought in. But if any interim order is there, the interim order will continue. Please come. Perused the report forwarded by the officer in charge. SARFACI section. Office of the District Magistrate, South 24 Parganas, wherefrom it is clearly evident that the bank filed the affidavit before the District Magistrate disclosing that the secured asset is not in possession of any lessee / sublessee / tenant under the valid lease made prior to creation of the mortgage by the borrower. Stop. The petitioner has annexed the copy of the decree passed by the learned civil court in his favor. On 24th of June 2016. Stop.
22nd June 2016, the judgment. Date of judgment. And date of decree is
24th of June.
yes. Date of decree is 24th June.
In title suit number 5761 of 2013, passed by the learned civil judge within bracket Junior Division 3rd Court, Alipur, South 24 Parganas. Stop. The suit was filed by the petitioner against his landlord, seeking declaration that he is a lawful tenant in premises number
Plaintiff is at 271.
in respect of lawful tenant in respect of one room with asbestos shed within bracket workshop on the ground floor of premises number 164 Caps A, comma, Shama Prasad Mukherjee Road, comma, PS Toliganj, Kolkata 70026. Acha. Learned advocate representing the bank submits that the borrower never disclosed the fact of the tenancy at the time of obtaining the loan. It has further been submitted that it is not believable that the petitioner, being a tenant, the petitioner claiming himself to be the tenant of the subject premises, will not be aware of the steps taken by the bank to recover possession thereof, as various notices were affixed on the outer wall of the said premises. Stop. Reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of PHR Invent Educational Society versus UCO Bank and others, reported in 2024 6 SCC 579. On the submission that the High Court will not entertain a petition under Article 226 of the Constitution if an effective alternative remedy is available to the aggrieved person, or if the statute under which the action complained of has been taken itself contains a mechanism for redressal of grievance. Achha. Admittedly, in the instant case, it appears that the petitioner was in existence, was in possession of the subject property which was mortgaged. Acha, was, ki bola? Is in possession of a portion of the
Part of the
subject property which was ki bola? Mortgaged to the bank. The petitioner was already in possession.
Lordship's last day's order delineated the entire description.
ठीक है sir? Stop. By virtue of the order of physical possession, a lawful tenant ought not to be evicted. Stop. Learned advocate representing the bank seeks further time to rely upon precedents in this regard. On such prayer, the matter stands adjourned till
You must kindly keep this next week, any day.
next Wednesday.